Adrian, can you hear me?
Yes.
Is there feedback or is it okay?
No, it sounds okay.
Perfect. Okay, thanks.
It looks like we're still waiting on a couple people.
There we are.
Okay, let's see. Ms. Fox, do you know if Eric Schlenker-Goodrich is joining us this morning or not? I don't think we can hear you.
This is Adam Rankin. Mike Follower will be joining us shortly. He's was having trouble with the link, so he's going back through the docket link. I think that's the one that works best.
Okay, yeah, if they can't get in through the panelist link, just join with the regular attendee link and I can push them over.
Hello, can you hear me?
Yes.
I can't hear you.
Oh.
I'm not sure my audio is working.
We can hear you, Tennis.
Yeah.
I'm not quite sure what to do. I can hear, yeah, you can hear me. I can't hear, but I can't hear you, Commissioner. Let me check my volume here.
You might want to check the settings for your audio. It may be set on headphones as opposed to speaker. Or if you used it with a television, it might be set for the television as opposed to the laptop.
For people who have, this is Ari Birnoff from the Land Office. For people who have technical problems during the course of this hearing, is there a phone-in number as an alternative? Is that possible with this platform?
Yes, there is. That's a good thought.
Let's see. So I'm sorry to interrupt. My volume has been working for months. It is not now. I'm going to go to another device.
There's Mike. I see you.
While we're waiting for Ms. Fox to try to get her audio going, Irene, are you able to hear us?
Yes, you guys are coming in loud and clear today. Thank you.
Okay, great.
Let's see, for the time being, I'll just join by phone.
So I will watch and see when she is able to join. We'll give it another couple minutes and then we'll go ahead and get started.
Apologize.
Madam Chair, may I ask you a question about the links you
Yep.
sent, the emails you sent last night with links for the hearings?
Yes.
We're expected to send those to our witnesses, is that correct? Is that how our witnesses will join as well?
No. So because there are so many witnesses, all of the lawyers of the parties were sent 11 different invites, one for each day. So you probably got bombed a little bit last night. Your witnesses will join as a normal attendee, and then once it's their turn, we will basically move them over from an attendee to a panelist.
Thank you. So
And
they'll enter using the link in the access codes that are attached to the scheduling order, and then you'll admit
Correct.
them one by one. Great.
Yes.
Thank you.
Ms. Fox, I think I unmuted your phone. Can you speak? Can you try to say something?
Oh, that did it. Is that it?
So try now.
Can you all hear me?
Yes, Mr. Featherwort, we can hear you.
Adam saved me.
All right, Ms. Fox, I think we're still having trouble hearing you.
I could totally relate to that.
You're like very far away. Can you put the phone closer?
Can you hear me now?
It's very hard. Is everybody else having a hard time? Yeah.
Yes.
This is so odd because I've been using Zoom for months and this
Madam Chair.
happened.
Do you have headphones that you could plug your phone? What about like turning it the other way and talking like directly into the microphone?
Madam Chair, this is Irene.
Yes.
Maybe if she tries to log out and then log back in, and let's see if that fixes it.
Okay. Maybe keep your phone on, Ms. Fox, and see if it's just the computer side. We're going to get better at this over the next 10 days.
Now that the computer is off, can you hear me better?
No, it's just like, it's almost like a faint echo.
Madam Chair, this is Tom Engler. While we're waiting as a follow-up to Mr. Ains' question, I sent you an email last night about those invites for next week.
Yep.
I don't have them.
I will work on that today. I got a couple of you who are missing some.
If you don't want me, that's fine.
I don't have it either.
No, you don't get off the hook that easy.
Director, I didn't get them either, so maybe they just got sent to council.
Okay, I'll
She
check.
didn't want you either.
No, you guys, I don't think get out of it this easy.
Alex, try unmuting your computer and then try talking.
I can't hear her.
Madam Chair, I'm showing there's now she's unmuted.
So can you hear me if I unmute my computer?
Yes.
Yes.
I'm listening to you on my phone.
Oh, goodness. Okay. We're not getting feedback. Can you hear us? Okay, well then maybe this will work. All right. Well then, it's only 14 minutes past the hour. That's not too bad, actually, I think. All right, well, good morning, everybody. It is 8:14 and today is a special meeting of the New Mexico Oil Conservation Commission. I am Adrienne Sandoval. I am chair of the Oil Conservation Division or Commission and director of the Oil Conservation Division. Also with me today are the two other commissioners. Would you please introduce yourselves for the record, starting with Dr. Engler, please?
Yeah, this is Dr. Tom Engler, and I'm the secretary designate.
Morning, Jordan Kessler, designee of the State Land Office Commissioner.
Also with us today is Chris Molander and Sally Malave from the New Mexico Attorney General's office. And hopefully joining us shortly is Florine Davidson, clerks to the commission. On today's docket, we just have one item in case number 21528. And with that, I will introduce Felicia Orth, who will be acting as the hearing examiner for this case on behalf of the Oil Conservation.
Good morning, everyone. Madam Chair, can you hear me?
You're a little quiet on my end.
All right. We turn it up. Is that better? Okay.
Yeah, I can hear you. Court reporter, are you good?
So, Felicia, can you actually say something again?
Yes, good.
I got you.
All right, thank you.
And Felicia, just hold on a sec. Sorry. If everybody can make sure to try to mute when you're not speaking so that there's not any background noise, that would be helpful. Okay, go ahead, Felicia. Thank you.
All right. Good morning. My name is Felicia Orth. Our task this morning in case number 21528, the application of the Oil Conservation Division to adopt 19.15.27 and 19.15.28 NMAC, and to amend 19.15.7 and 19.15.18 and 19 statewide, is a motion hearing on the motion of the New Mexico Oil and Gas Association to strike section 19.15.27.8.G4 from the proposed Part 27 rule on the venting and flaring of natural gas. That motion was filed timely under the amended procedural order entered earlier in this matter. We had replies filed, about 36 hours ago, from the New Mexico Oil Conservation Division, from the Commissioner of Public Lands and the New Mexico State Land Office, and from a group referred to as the Climate Advocates. If I might please have appearances from each of the council. Would the movement please begin?
Yes, this is Michael Felderwart with Santa Fe Office of Holland and Hart. With me is Mr. Adam Rankin, and we are appearing on behalf of the New Mexico Oil and Gas Association.
All right, thank you. Mr. Ames? I can't hear you if you're speaking.
That was not an auspicious start. Good morning, Ms. Orth. Good morning, Madam Chair, members of the commission. My name is Eric Ames. I'm an Assistant General Counsel in the Office of General Counsel for the Energy, Minerals, and Natural Resources Department here today on behalf of the Oil Conservation Division.
Thank you. Mr. Birnoff?
Good morning, Madam Hearing Officer and commission members and fellow council. This is Ari Birnoff for Commissioner of Public Lands, Stephanie Garcia Richard, and the New Mexico State Land Office.
Okay, and Ms. Fox?
Hello, commissioners and Madam Hearing Officer. My name is Tanis Fox. I'm here today with David Bach, trying to manage the technology and appearing on behalf of 8 nonprofit organizations that we're calling climate advocates.
Thank you. I've studied the motion and all 3 of the responses. I know that the amended procedural order did not allow time, or there was no time to allow for a written reply. So I had thought that this morning the best use of our time would be to hear a reply to the 3 responses. I believe at that point we can move expeditiously through this motion hearing. Mr. Felderwart or Mr. Rankin? If you're speaking, I cannot hear you.
There we go. Can you hear me now?
Yes.
Sorry about that. So, Madam Examiner, members of the commission, the division, as you all have gleaned, have submitted a package of proposed rules that seek to address surface waste, and in particular, venting and flaring. And surface waste is defined as the unnecessary or excessive surface loss without beneficial use. So not all venting and flaring is surface waste, only that which is unnecessary or excessive or doesn't provide a beneficial use. So as part of the effort to address the unnecessary and excessive venting, the division has proposed a subpart G. And is there a way that I can share my screen?
Give me a second. I should be able to give you permission.
Thank you. Just trying to say all these letters and numbers gets a little confusing.
You should be able to now. There should be a share little box on the bottom of your screen.
Can you see OCD Exhibit 2?
Yes.
Okay, great. So as part of this effort, the division has this, and I'm using their Exhibit 2, which is their modifications to what's been filed. They have proposed down in subpart 27.8 G 2 that operators are to report to the division the volume and percentage of vented and flared gas. It's initially going to be done quarterly, and then as the systems come online monthly. And the information, as we understand it, is going to be posted on the division's website for anyone to see. Whether you're the state land office, you're a working interest owner, you're a royalty owner, an override, or any member of the general public, in a format, much like they're doing now, that everybody can access and understand. That NMOGA's motion is not directed at that provision. NMOGA's motion is directed at a subsequent provision, which is, I'll call it 27.8 G4, which requires the same information to be reported monthly to all royalty owners in a wells spacing unit. Now, by definition, royalty owner in here means overriding royalty interest owners. And by report, the only way I'm aware of that you report or could report is mailing. So we're talking about mailing the same information, the same reports to all royalty interest owners and overriding royalty interest owners. As you know, I know Ms. Orth knows, I know some of the members of the commission know from pooling cases. Royalty interest owners and overriding royalty interest owners can be very numerous. And when you're in these municipalities and other areas, sometimes there can be hundreds of them for each spacing unit. And many times, as we know, an operator does not have contact information, particularly for overriding royalty interest owners. So you pool by notice in the newspaper. This proposed duplicative monthly mailing to all of these royalty interest owners and overriding royalty interest owners may not be possible in some circumstances and is a burden that is simply not warranted here. When you think about a spacing unit where a well is going to be located, there are at times multiple working interest owners in that spacing unit. Each of those working interest owners have related royalty or overriding royalty interest owners that burden their working interest by contract. So when you create a spacing unit and you account for a particular working interest owner's share of that spacing unit, the net percentage for these royalty interest owners or overriding royalty interest owners in the production from that spacing unit can be very, very small. Sometimes, a lot of times, less than 1%. We also know that there is no dispute. The respondents don't dispute, and you all know this. Royalty interest owners and overriding royalty interest owners have no correlative rights. They have given up the right to produce and sell the oil and gas to the working interest owners. They've given up control of operations. They have no authority to direct how oil and gas is produced, saved, and sold, or when venting and flaring is or is not necessary for things like safety, beneficial use, efficiency, or other justifiable reasons, because not all venting and flaring constitutes waste. So it is this added duplicative monthly mailing burden to all these small interest owners with no operating rights that NMOGA takes issue with.
Mr. Feldman,
And when we inquire, I'm sorry?
I'm sorry to interrupt you. I really did study the motion. I was hoping you would focus this morning on your reply to the responses, and in particular on their essential message that this is these are the factual statements that you are making about the burden of mailing and whether there's a benefit associated with that burden, that's the sort of thing we ought to be hearing next week as part of the evidentiary hearing.
Well, I think we need to understand the background, and maybe this helps. I mean, when we inquired into the basis for this proposal, okay, all we heard was that it might assist in the prevention of unnecessary and excessive venting and flaring. And we said, how? We're dealing with very small interest owners with no operating rights. And when you look at the responses, the proponents of this provision still have not articulated or demonstrated the how or the why with this monthly mailing. How or why a monthly mailing to a Mr. Jones or a Mr. Smith or some of these estates that you see with these overrides, how that is going to assist in the prevention of unnecessary or excessive venting and flaring. They simply state that sending the same information filed with the division to all of these hundreds of royalty and overriding royalty interest owners, first they say it's appropriate. They say it falls under the division's statutory authority to do whatever is reasonably necessary to prevent surface waste. And I'm going to try to move my screen here. I need to stop. I guess I stopped sharing first. So I'm bringing up the response. Am I still allowed to share? Yes. Can you all see the response?
Yes. Yeah.
Thank you. So what they cite is down here on page 3. And they cite the division's statutory authority. I'm very well familiar with this. You are all well familiar with this. 70-2-11, it says you can do whatever may be, and this is key here, reasonably necessary to prevent surface waste. And here, address venting and flaring. Yet after relying on this statutory authority, they still do not explain the how or the why this monthly mailing obligation is somehow reasonably necessary to the prevention of unnecessary or excessive venting and flaring. They just offer pure speculation. I go down here to page 4. The MOGA argues that OCD's proposal does nothing to further the Commission's duty to prevent surface waste. Here we're focused on unnecessary or excessive venting and flaring. OCD disagrees and intends to present testimony that requiring operators to disclose their waste of natural gas to working interest owners. I don't know why they reference them. This provision only goes to royalty interest owners and overrides. And they say that if we send it to royalty and overrides, it is more likely than not to encourage operators to prevent that waste. That's pure speculation. More likely than not is not even a statutory test. The statutory test is whether it's reasonably necessary to prevent unnecessary and excessive surface loss. And that cannot be met here. Any royalty interest owner, overriding royalty interest owner, any Mrs. Jones, any Mr. Smith, any estate that holds these interests, who are even interested in vented and flared volumes, will be able to go to the division's website and review all of this information on venting and flaring provided to the division in a format understandable to the public. Nothing is gained, nothing further is gained by sending that same information monthly by mail to hundreds of royalty interest owners and overriding royalty interest owners who have small interests in the gas that's produced, saved, and sold, who have no control over operations, and who for the most part have no interest in operations. So my point here is they're relying on that statutory provision, reasonably necessary, but they don't even attempt to demonstrate why this duplicative monthly mailing is reasonably necessary to prevent unnecessary and excessive venting and flaring, because that test cannot be met here for royalty owners and overriding royalty interest owners. And that's why our motion should be granted.
Thank you, Mr. Feldewart. Mr. Ames, I have studied your response. Do you have anything to add at this point?
Yes, I do, Ms. Orth. Now that Mr. Feldewart has reprised his entire motion, I think that we ought to be allowed to reflect on a few of the key points in ours, as well as respond to the arguments he has just made. First, the motion is not supported by the statute. It's not supported by the case law, and it is not supported by any evidence because there is none yet. I won't reiterate the case law, which is, or the statute or the case law, which is fully explained in our response and which Mr. Feldewart appears to concede is applicable here, specifically section 72-2-11A. What Mr. Feldewart fails to do is address the fundamental issue that this is not an evidentiary proceeding. The evidentiary proceeding is going to happen next, and that is where evidence will be presented regarding the arguments being made. Mr. Feldewart suggests that the division's not properly articulated or demonstrated the evidentiary basis for its rationale. But of course, our demonstration is to the OCC, not to a party. And we don't need to do it here in the context of a motion prior to the hearing, which is being held for the express purpose of taking evidence. OCD simply explained its rationale in the motion in order to, or in its response to the motion, in order for the commission to have a better understanding of its intended testimony. As Mr. Feldewart quoted accurately from OCD's response, OCD intends to present testimony. That is the purpose of the hearing. That is not the purpose of this motion practice today. As for the burden issue, I think this is fairly interesting. As Mr. Feldewart acknowledged, operators send royalty statements to royalty owners all the time. They explain quite a bit of information in there. These statements are readily available on the website. Many of the operators publish guides on how to read their statements. All OCD is proposing is to add another data box to the statement. NMOGA claims this will be too hard for it to do, too burdensome. It's a bit hard for OCD to accept. The oil and gas industry has perfected hydraulic drilling. It bends well bores through rock miles below the surface of the earth. It's learned to drill in the most extreme environments on Earth, the ocean, the Arctic, the desert. The industry is asking the commission for performance standards rather than prescriptive regulations, and OCD has acknowledged that in its proposals because the industry says its engineers are creative and innovative and are adept at solving technical challenges. OCD agrees. We see it every day. All we're asking is that the industry report some additional data that it's already going to be required to report to OCD on a statement it already issues to royalty owners. Now, perhaps NMOGA will present compelling evidence of the testimony to show that this is too hard to do and that royalty owners won't care if their gas is being wasted and they're not getting paid for it. But we haven't had the hearing yet. The hearing is the place where all the evidence will be heard. Arguments of counsel are not evidence. Everyone knows that. And certainly arguments now by counsel are not evidence when we have not even had the evidentiary proceeding. So given that there's no real dispute regarding the statutory authority on which OCD rests its proposal, given that there's no evidence to refuse OCD the opportunity to make its proposal and present evidence in support of it, the division respectfully requests that the motion be denied.
Thank you, Mr. Ames. Mr. Biernoff, I did read your response, and in particular, your statement that, in fact, the State Land Office is a royalty owner in many of these areas. Would you have anything to add to what you've already written?
Thank you, Madam Hearing Officer. All I would add to what Mr. Ames has, I think, very eloquently explained in his response to the association's argument. I look forward to learning from the association during the hearing a little bit more about why this additional reporting requirement that's in the proposed rule is so onerous. I heard association counsel say that snail mail is the only way to report, and that certainly is foreign to my agency's practice. We receive a lot of information electronically, and I'm sure that the association's members are, along with the land office, living in the 21st century using email, using electronic documents. So that's a question that I have more for the association than for this tribunal. The land office does have an interest as a royalty owner in receiving this information. And given that adding the land office in this case, or other royalty owners, to an existing report seems like a negligible burden, having that information readily accessible and having it guaranteed and not dependent on a third party to mediate is something that's important to us. And for that reason, we would support the existing requirement. But really, this is getting into the merits, which is something that we hope we'll do during the hearing. I think Association Counsel made abundantly clear in his presentation that there is no jurisdictional argument. There is apparently an efficiency argument or a burden argument, and that is well suited for testimony over the next few weeks, but certainly not for this ill-considered dispositive motion.
Thank you, Mr. Biernoff. Ms. Fox, I read your response and wondered if you had anything to add to what's already been said in writing or by the other counsel this morning.
Madam, David Bach is going to respond.
Thank you. Mr. Bach?
Thank you, Madam Examiner, and thank you to counsel and the commission. We don't have a lot of additional points to make. I think that we are probably the least familiar with the procedures that are currently in place of parties here. We do think that it's not a good precedent to set for any language to be struck on the basis of a motion practice when it turns on evidentiary considerations. And we think that the argument that was presented by Namoga quite clearly presents factual questions. And as a participant in this hearing, we think that that evidence should be presented by testimony, and then we and other parties should have the opportunity to cross-examine, and if we choose, put on a rebuttal evidence. Just like any other proposed change to the rule, we have copious red lines, as do all the other parties, but no other party has decided that one of their red lines be allowed to, this should be able to short circuit the evidentiary hearing and have that red line adopted based on a motion. So we would join the division and the State Land Office in opposing the motion, and frankly not certain where we would end up on the merits. I mean, Moga may have good arguments. We may, if indeed there's a regulatory requirement that these statements be mailed, we would, understand why that requirement should be changed and allow for email service. But until we understand more what's going on here, we think the motion should be denied. Thank you.
Thank you, Mr. Bach. Mr. Feldward, I'm going to invite you and your clients to put on the evidence that supports the factual statements you've made in order to support your arguments that section 19.15.27.8 G4 would not be a wise provision to adopt. Of course, all the other parties can put on their own evidence about that section. The motion is denied. Madam Chair, the motion hearing, Mr. Feldwart?
Yeah, may I be heard on just one point here?
All right. Please go ahead and please keep it short. Again,
Sure.
I invited your reply earlier.
Okay. The commission invited motions. So why we filed it. So we look at this provision and we ask, okay, what's the statutory authority? And they say, well, the statutory authority we're relying upon is that it's reasonably necessary to prevent surface waste. So the next question is then, and what they have to show is why it's reasonably necessary. That's why we filed the motion.
I understand.
Okay.
And if you had not filed the motion, perhaps there might have been an argument that you had waived such an argument. I understand that each of the council in this matter have a number of different aspects of the proceeding to consider, including the strength of, their posture on appeal, for example. Having said that, I truly believe you need to put on the evidence that would support the statements you made in your motion, and that is for our hearing next week. And
I understand. And my point is, the steps are, what's the statutory authority? They finally told us in the motion, in the response. They say it's reasonably necessary. They have the burden of demonstrating why it's reasonably necessary. And my point that I was going to make is that in the normal course of process, when you file a motion like this, it's in the form of a summary judgment motion. And parties are required by due process and the rules that govern those to make a prima facie case meeting their burden. That's what the case law requires. Now, I know I'm going to hear that it doesn't apply here, but that's normally what happens. And so the reason we filed the motion is to understand their statutory authority. And in the normal course of events, they should have demonstrated, at least made a prima facie showing as to what they were going to present and how it was going to demonstrate that it's reasonably necessary. They did not. And I understand you want to leave that for the hearing.
Yes.
Okay.
Thank you very much. Now the motion hearing is adjourned, and Madam Chair, I will return the virtual gavel to you.
Thank you, Ms. Orth. I believe that was the last item on today's agenda. Let's see. It was. So with that, it is 8:47.
Madam Chair?
Yes.
I have a few preliminary matters, procedural matters, but I'm hearing echo. Are you hearing my echo?
Yeah.
If I unhook my earphones, does that work?
A little better.
Yeah, it's a little better.
Because now I can't hear you. In any event, I have a few procedural matters that I'd like to raise at this point if I could.
Okay, go ahead.
Thank you. First, one of our witnesses, Adela Begay, has a conflict for testifying because she has a new job and she also has to travel. in order to secure reliable internet. And she's available to testify the morning of January 8th. And I've consulted with all counsel, and everybody is agreeable to allow her if we're not in our case at that point to go out of somebody else's direct case and present Ms. Begay the morning of January 8th.
I believe that Miss Orth is going to be, and Felicia, please correct me if I'm wrong here, but working and contacting all of the different councils to sort of develop some of that scheduling in the next couple of days. Is that correct, Ms. Orth?
Yes, certainly in any long proceeding, and I think this qualifies as a long proceeding, we do make accommodations for the schedules of certain witnesses. I would plan to have a conversation with all counsel whereby we talk about the order of presentation. I'm hopeful that the parties, obviously the division will proceed first as the rulemaking petitioner. I'm hopeful that the other parties can reach some agreement as to their arrangement. Otherwise, I will set out that arrangement myself. Again, we do accommodate certain witness scheduling conflicts, and I'm happy to put Ms. Begay Friday morning, particularly since you've already discussed that with other counsel.
Thank you very much, Madam Hearing Officer. One of the other points I wanted to bring up was the order presentation. But if we're going to do that through a conference call or WebEx that works for me, then we can talk about that at that time. One other point I wanted to ask about was the date by which the public has to make requests to provide oral public comment. Some partners were told by the MNERD, I believe, Public Information Officer, that members of the public had to make a request to provide oral public comment by January 3rd. But that is not in the instructions or the procedural order. Is that true, that you have to, even if the hearing lasts for the next 2 weeks, that the public needs to request to make oral public comment by January 3rd?
Yes, and I'm trying to pull up the scheduling order or procedural order, and that was specified in there. You have to make your request for written public comment. I'm sorry. You have to make your request to make a public statement at the hearing by 5 o'clock on the 3rd. You can submit your written public comments by the end of the day on the 8th. And so there are 2 dates that are moving. One is the oral public comments at the hearing, which you schedule with the commission clerk. And 2 was the written, which is that people have till the end of the day. I think it's whatever that Friday is, the 8th, to do that.
Madam Chair, maybe I'm missing something, but I do not recall that there was anything in the orders that required people to make those requests by January 3rd. Certainly it's in the orders that they have to submit written comment by January 8th. I'm just a little worried that because the hearing begins January 4th, public comment is taken through the 15th. I'm worried that we may unnecessarily cut off oral public comment.
I'm trying to pull up. Mr. Moander, do you recall this offhand?
Let me pull up. I just got kicked off my server and I'm mining back in. So give me a moment to look at that.
Because I know that the commission discussed it at the hearing in November, that everybody needed to sign up prior to the hearing, and I believe that is on the record. They can sign up anytime we reserved those times. So on January 3rd, you could sign up for the 8th or the 12th. And there is time reserved each day.
I'm sorry about having to fiddle with everything. My internet just took a flying leap off a cliff, apparently, except for this application where I can talk to you guys. Convenient. Give me a minute here. I'll be right back.
Madam Chair, members of the commission, I'm looking at the amended procedural order, R21540A. Is that what you're looking at, Ms. Fox?
Yes, am I missing something there?
I don't think so. I'd have to agree with you. I see a date for written comment, a deadline for that. I'd have to confess I don't see one for any restriction on our deadline for public comment at the hearing.
And in looking at this, I think that is right. That is not specifically addressed.
And Madam Hearing Officer, there's instructions on the website for how to submit public comment, and those dated November 24th. And those instructions don't have a final date. And so I'm wondering if there can be some kind of a accommodation for this in the event that people want to submit, want to request to provide oral public comment after January 3rd.
Mr. Moander, I believe that we did discuss this at the hearing on the 3rd. And I mean, before we make some sort of decision here, that transcript needs to be reviewed and make sure whatever the commission's intent at that meeting is fulfilled.
Yes, and I'm looking at that to see if that was something that was overlooked. So.
Would it be better to reach back out to the parties not on this forum, Mr. Molander?
Yeah, I think it will, because I want to go back through the transcripts again and see if I can find a basis for that, if it was actually discussed in the way that it's being described. All right, so I can take a look at that. I think we still have enough time. Yeah, like we'll see what we can do about that, because I think there should be something that can be accomplished with it. I'll turn right to this topic and get this addressed.
Thank you, Mr. Moander and Madam Chair. I have a number of other sort of very kind of logistical things like, and I wonder if this is better for the discussion, if we're going to have a discussion with the hearing officer over the next couple of days, but things like we will want to present documents or the testimony of a few of the witnesses to the commission and council. And normally in a hearing, we would just hand it out, in hard copy to everybody. We're not able to do that. And so I'm wondering if we can develop a procedure to make sure that all the commissioners and council, court reporter, get the documents we would like them to see. And specifically, I'm thinking of several of our witnesses who have their written testimony that they would like commission and council to have. I'm wondering if there can be maybe an email procedure in order to accomplish that. And, you know, another issue is what just happened to Mr. Moander. What happens if somebody gets kicked off the internet? I know at the very first meeting, at the very end of that meeting, I got kicked off my internet, and I didn't have co-counsel then. And so luckily it was at the very end, but I was nonetheless kicked off. And so I'm wondering if there needs to be some kind of procedure where we can alert somebody that if we get kicked off. But there's things like that I don't know if you want to discuss now or if it would be preferable for us to discuss this with the hearing officer over the next couple of days.
I think it would probably make more sense to have that discussion offline with the hearing officer and make sure that we have all of those kind of procedures set. I think we also at that November 4th hearing discussed how to distribute exhibits and things like that, because we had issues with that at the last rulemaking hearing and wanted to make sure that process went smooth this time. So I believe we just had some discussion of that during that hearing. And so also, Mr. Moander, it might be good to review that transcript for that information as well, so that discussion can be had with counsel and the hearing examiner.
I guess I have one question. I mean, I'm not sure what Ms. Fox is referencing. I mean, I know everybody painstakingly pre-filed what they intended to use as an exhibit. So I don't know, are you talking about rebuttal exhibits, Ms. Fox?
No, Mr. Feldward, I'm just talking about our witnesses getting up, giving their presentations, and their presentations are in writing. So they'll be giving them orally, and then the commission and council have the benefit of those presentations in writing. No new exhibits.
So let me ask, this is Felicia, let me ask, because I was fairly recently appointed, when would be a good time? I had thought we would discuss, for example, at the beginning of the hearing, some of the logistical things based on the commission's discussions that they've already had. But I'm happy to have a discussion even before that with all of you. Among other things, for example, my phone number, my only phone number, is in the bar directory, so it's no secret. It's 505-695-8944. I want you all to know that if in fact you are abruptly kicked off the internet, that if you reach out to me by text, I will almost certainly see it immediately and will be able to take whatever action might be appropriate at that point. So we are all together now. I know that this motion hearing was ostensibly scheduled to proceed from 8 all the way to 1, I believe, and we didn't need that much time. Let me just ask then, if this is a good time, we could let the commissioners go and perhaps take a 5-minute break, come back and just discuss logistical matters. Is this a good time to do that?
Madam Examiner, it works for me.
Madam Chair, it works for me as well, though I do have one issue that may require the commission to weigh in. It's not purely a logistical issue. It regards the necessity to qualify witnesses as experts in this proceeding. If you're comfortable making the decision on that, I'm fine with it. If you believe that the commission ought to participate in that decision, then they would need to hear my argument on that.
All right, Madam Chair, let me ask as to that point specifically, would the commission want to be part of that discussion?
Yes.
Okay. So Ms. Fox, are you and Mr. Bach still available to have this discussion if we proceed this morning?
Yes, we are.
And Ms. Orth, Ms. Paranjos is also on the call for EDF.
Oh, thank you. Ms. Paranjos, are you available to proceed with a logistical discussion this morning?
I am, Madam Hearing Officer. Thank you.
Thank you. All right.
And Mr. Biernoff.
And Ari as well, yes.
Yeah. Mr. Biernoff, are you still with us?
I'm here, Madam Hearing Officer.
All right. In that case, Mr. Ames, why don't you bring up, while we have the commissioners with us, why don't you bring up the point that about qualifying experts?
Great. Thank you, Ms. Orth. The division requests clarification that the parties will not qualify witnesses as experts in order to present their testimony, specifically their opinions. Rules don't require it. It's not been historically done by the commission in rulemakings. There's no need for it. And in our view, it could bog down the proceedings unnecessarily. In general, under the rules of evidence that apply in state and federal courts, to present an opinion by a witness, that witness has to be qualified as an expert based on their education, training, and experience. That is not required by OCC's rulemaking rule 1915-3 NMAC. 1915-3 NMAC specifically says that the rules of evidence do not apply, and there is no other requirement to qualify witnesses. The only specific reference to witnesses is in the pre-hearing statement provision, which says that you need to explain their qualifications. Historically, at least in the last, at least as far back as when Bill Brankard was serving as commission counsel, the commission did not qualify witnesses as experts in order for them to offer opinions. In my personal experience, the two rulemakings that the commission did in 2020, the compliance rule and the produced water hearing, there was no qualification of witnesses. It is not needed. In a rulemaking, anyone can give an opinion, and it will be considered as long as it's relevant. The commission is fully capable of giving the weight appropriate to that opinion based on the qualifications of the witness as presented during the introduction of their testimony and their credibility, frankly, during direct and cross-examination. And then finally, in our view, having to qualify witnesses has a real potential of slowing down the process. The parties here have 30 plus witnesses. It should be enough for us to introduce our witnesses, allow them to explain their qualifications, introduce their CVs, which have been distributed by the parties to everyone else, and then proceed with the testimony. Qualifying witnesses is a potentially hazardous area for us to enter. It invites side disputes over qualifications. It invites objections during the testimony to the scope of the opinion being offered, whether it's really within the scope of the qualifications of the witness. And frankly, if one party does it, then all the parties will have to do it in order to protect themselves in the event of an appeal. So in our view, qualification of witnesses is not required by the rule. It's not historically done in rulemakings. It is not needed, and it could potentially waste a considerable amount of time in what is anticipated to be an otherwise already lengthy proceeding. Thank you.
All right, thank you. Mr. Biernoff, do you have comment on this issue?
Thank you, Madam Hearing Officer. I think Mr. Ames' point is well taken, that the time allotted for the hearing would be better spent developing testimony and asking questions of the various witnesses. And given that the qualification process is not necessary, I don't think we see a need for that to take place during the hearing.
Thank you. Ms. Fox?
Madam Hearing Officer, members of the commission, we don't have anything to add to what Mr. Ames said. I think he articulated the bases for not qualifying witnesses very well. I would just reiterate that we believe that the commission is fully capable of hearing the direct testimony of witnesses, of evaluating their credibility, their qualifications, and after hearing cross-examination, of giving the weight the testimony is due in their minds.
Thank you. Ms. Paranhos, anything to add?
Thank you, Madam Hearing Officer. I would just agree and support what Mr. Ames has said. I would just add, in addition, I don't practice normally in New Mexico, but I do practice in Colorado before multiple different regulatory bodies here. And in rulemakings in Colorado, it is not common to qualify witnesses. So just as a side note, just wanted to let you know that.
Well, thank you for that. And Mr. Felderwart or Mr. Rankin?
Yes, I mean, I don't, the only thing I can add to what's has been said is I recognize the time constraints. I do know that certainly when Miss Jamie Bailey was the commissioner and we had rulemakings, they would qualify witnesses as experts. I know they did so in the pit rule proceedings a number of years ago. But Mr. Ames is correct. There have been more recent rulemakings where that has not been a requirement. So, I think it's up to the commissioners as to whether they think it's worth the time and effort. I do agree though that normally that if you're going to have someone offer an opinion, they do so after being recognized as an expert in a particular area.
Right. Thank you, Mr. Felderwart. Mr. Moander or Ms. Malavey, do you have guidance for the commissioners on this point?
Well, I actually got a question, and this may just reflect my own ignorance and the need to learn. In order to present technical testimony, I'm thinking of just looking at this as from a trial lawyer's perspective, which is probably part of the problem. But in order to have technical testimony, it seems to me that you would need to somehow qualify a witness for that purpose. And that's my instinct. Now, maybe that's a misplaced one, but can any of the parties maybe educate the commission as well as me who oppose qualifications? Because it's my experience that unless there's a strident objection, qualification of this expert usually doesn't take too long, and it's fairly straightforward with the background training experience approach that most lawyers prefer. So I'm just sort of curious as to why that would be a problem here, given the scientific nature of the evidence that's going to be presented.
Mr. Ames, would you like
Sure.
to address this?
Sure, I'll try and answer Mr. Moander's question. He is right that in court, qualification is required for a witness to offer an opinion based on something other than their 5 senses. But we are here in a rulemaking under the commission's rules, which expressly state that the rules of evidence do not apply. As for the issue of whether or not it will be a problem, I would hope that Mr. Moander is correct, that it would not be an issue and that parties would not object to the qualifications of other witnesses or of other parties' witnesses, or would not object to testimony when it's offered on the grounds that it exceeds the scope of their qualifications as accepted by the commission. But there's no guarantee of that at all. And given that there's no guarantee, then the parties will have to lay the foundation strongly for the qualification. Normally, it should suffice for a party to introduce its witness, ask a few questions regarding their background, their current position, and their experience, and then proceed to allow them to testify. The CVs are already in the record. The commissioners and the other parties can look at those CVs and evaluate them and ask questions on the basis of that if they want. But if we have to qualify, if it's a free-for-all in the qualification, then we're going to have to do a lot more ground laying up front, because there is no way that any party can predict that another party will, whether another party will challenge the qualifications. And then finally, I'd say it's a bad precedent for us to be setting in a rulemaking. Rulemakings are inherently or essentially legislative functions. It is the commission's obligation during rulemaking to take all the evidence in and evaluate the evidence based on their perspective of the credibility of the witness. A witness being qualified should not, in and of itself, elevate that testimony more than it is worth as a matter of credibility. And so I think it's inappropriate in a rulemaking to qualify witnesses. And given, as Mr. Felderwert agrees, as we all agree, this hearing is going to take long enough. And if we have to layer in the necessity to qualify, then we are imposing on ourselves an obligation as council to do a complete and full job. And that has this significant potential for protracting this proceeding.
Thank you, Mr. Ames. I appreciate that.
And if I may, this is Sally Malave. I would add that in the actual rule making, in the rule, the technical testimony, the pre-hearing statement already includes the witness's qualifications, including a description of the witness's education and experience. And so I would say that, you know, that's already in the record, and unless a party has a reason to dispute that there's no additional to go further than to, you know, for the additional qualification, because it's already included in the pre-hearing statement as to what their qualifications are.
All right, thank you. So do any of the commissioners have a question about what is being proposed and apparently agreed upon by really all counsel or counsel for all parties in this matter? Just speaking as a hearing officer, I'll say that it would be different for me not to have the qualifications of those providing technical testimony in an administrative proceeding. There's even a Court of Appeals unpublished opinion involving the Water Quality Control Commission a long time ago. I think Ms. Fox was in that action as well, involving LES, Louisiana Energy Services, in which, for example, Ms. Fox objected to a man with a geography degree offering expert geological testimony. And I agreed with her, and so did the commission, and then ultimately so did the Court of Appeals. So certainly I'm going to be looking at the testimony that's offered in a way that assures that when the statement of reasons is prepared for the commission to adopt after it has made its decision, that in fact that statement of reasons is supported by reliable evidence, and that, you know, the reliability of the evidence supporting your decision would include, among other things, a consideration of whether that evidence was offered by folks who are competent to give it. So I think there's an aspect of it here that is not going to go away and can't be disregarded, which is to say the commission needs to be able to make its decision based on reliable evidence. Having said that, there are some hearings in which the qualification of experts goes smoothly, and there are others in which folks like to get down into the weeds, mostly as a matter of harassment. But that's never fun. I become impatient when that sort of thing happens. So, do the commissioners have questions about any of this?
Ms. Orth, I do have one observation, and I guess I would just say that I have concerns given the technical nature of certain portions of this rule and the involvement of extensive number of witnesses and the public in this about the ability of, how to phrase this, about the time that would be spent on potential testimony from non-experts related to opinions on technical matters weighed against the time that would be spent qualifying technical witnesses. So that's just a consideration that I'm trying to think through, whether or not it would take more time to hear all testimony, whether or not it was in fact from a technical expert versus qualification timeframe. So Mr. Ames, perhaps you could discuss that or help me think through that.
Thank you, Commissioner Kessler. Looking through the testimony of the witnesses of various parties, it does not seem to me that there are many witnesses who are likely to be offering technical opinions that they're not qualified to offer, or that they would not be qualified as an expert to offer. So I don't perceive there would be a significant amount of wasted time in that regard. And I would contrast that with the necessity for the council to lay a very strong foundation to qualify their witnesses in order for the record to accurately reflect the basis for the commission accepting them as experts. So I'm looking at a known versus an unknown, but in my view, the known is fairly significant. The unknown seems to me to be less significant. So that's the best I can offer on such short notice.
Miss Orth, may I add a few comments? This is Tom Engler.
Yes, please.
Thank you. I guess I actually do agree with Mr. Ames's request. I guess my viewpoint here is my definition of expert is probably a lot different from everybody else. And where I find the CVs are sufficient, I don't want to get into this discussion of what's qualified as an expert, because we all have different ideas what that is, and I know mine is significantly different from everyone else. I think the CVs are sufficient. I think council will prepare a good system and testimony for us. And so I would agree with Mr. Ames' request. That's my comment.
Thank you. Madam Chair, anything to add or ask a question?
I don't know if it's a question per se. I guess I just see a difference between when you're providing what people are terming here as opinions versus, talking about some very technical subject. And I see the validity in not requiring each expert to be certified. I also somewhat struggle with, is this person actually qualified to make these statements or assertions? And maybe that's just something that the commissioners have to weigh on each and every basis of who's testifying. We have to review their CVs and decide whether or not their testimony is valid, and weigh those options. But I somewhat struggle with this a little bit.
This is Sally. I would say that during the hearing, if the commission has concerns about a particular individual and their qualification to make certain statements, upon reviewing their CVs and the like, they can certainly ask questions to further to make that to be comfortable about accepting their testimony in terms of how expert they are.
This is Felicia, that's right. Proper cross-examination always includes questions about someone's qualifications.
And that makes sense. I mean, I ultimately, I see the reason to go this direction. Those are just some of my concerns up front. So maybe council can keep that in mind when you're presenting a technical witness.
All right. Is there anything else on this topic? No? All right. Thank you for raising that, Mr. Ames. And I'm happy to put that into a pre-hearing order if you think that's important to do before Monday.
Ms. Orth, I don't believe so. I think I may be shooting myself in the foot, but I imagine that all council around the table have heard the commission's perspective, and it's probably unnecessary to commit it to paper, unless, of course, you're going to be issuing a pre-hearing order anyway to deal with other issues, in which case it's probably appropriate to do.
All right. Thank you. So what other, are there any other, I don't want to push the commissioners out of this discussion, obviously, but let's hear the other logistical issues that might be, we might benefit from talking about this morning. I have to tell you, I have one I wanted to mention. I was not part of the produced water hearing, but I have read enough of that transcript and seen enough video excerpts to know that there were some disruptions, including some vile disruptions, and wanted to say that the engineers who will be controlling the buttons this time, it won't be me, it will be engineers, and controlling the settings, if you will, have been instructed to expel anyone who begins to engage in a vile disruption without repeated warnings. And part of my opening statement, if you will be to say that if in fact you are expelled, I'm going to invite you to make written public comment rather than oral public comment. Again, there will not be repeated instructions in the event someone starts cursing or otherwise behaving clearly inappropriately. Mr. Felderberg, I saw your hand.
I vote in favor of eliminating the chat room.
Well, so we talked about that as well, and as I understand our agreement, we've had some offline discussions, me and the engineering staff, specifically around what functions will be enabled during the hearing, and the conclusion that we've come to so far, I don't know that this will change before Monday, but our conclusion right now is that the only chat that will be allowed during the hearing is for someone to communicate directly with the host. And I don't mean me, and I don't mean Ms. Sandoval, I mean the engineer performing the host function for the hearing. That way, the engineer can try to address, whatever issues someone might be having without that chat being imposed on everyone else. Thank you for that, Mr. Feldor. Let's see.
Ms. Orth, I might just add something that I think maybe we should. So for the way that it's set up right now, and I think we hit on this a little bit earlier, all of the counselors and commissioners and the AG's office have all been made panelists. Everybody should have, I know some of you have a couple issues, which I will address, should get invites to join as panelists. If for some reason you're struggling with that, join as, a participant, and then the host can push you over when they see your name as a participant. So there is a mechanism to do that. I think as much as possible, it would be important during the hearing for myself, the other two commissioners, and Ms. Orth to have video on, I think as much as possible. Understanding sometimes there are internet issues. Got it. The other parties, it might be good if you're not speaking to just turn your video off. That might help with some of the bandwidth issues for people, so it's not getting bogged down by a bunch of videos. But if you are speaking, if you're presenting a witness, if your witness is on, please have their video on. It will be, I think, much more helpful than just someone calling in over the phone. Understanding, again, there are limitations and some things, issues with internet, et cetera, and maybe that's the only mechanism. But if at all possible, I think whoever is speaking should try to have their video on. I think it would be helpful for everybody during this hearing. Does that make sense to everybody? Do people have questions or concerns about that?
I totally agree. I think it's very important to be able to see the witness, and particularly if that witness is going to present technical testimony, I would hope that they would be available and can be perceived by video.
Yeah, I think that's important. If for some people too, if we have issues with the sound or something, you can call in by the phone. I would still encourage you to try to use the computer for the visual part of it. I do know that, internally when we're having staff meetings, things like that, sometimes it is hard for people to use their video because of bandwidth issues, if they've got kids who are, on the computer as well all day. So we understand that there are situations that, may override, but as much as possible, I think video would be good. But if you're not speaking, I don't know if we need the video so that we can limit the bandwidth suck.
All right, thank you. Ms. Fox, you mentioned other logistical issues. Do you have other topics?
Yes, thank you, Madam Hearing Officer. We dealt with Ms. Begay's scheduling, and I appreciate that. Next on my list was the order of presentation of the parties, which apparently is on your list too. And so I hadn't had an opportunity to talk with Mr. Ames or Mr. Feldward about this, but I did consult with other counsel, and a proposal that we have is for, obviously OCD will go first. And then the State Land Office could go because their presentation is rather limited and short. And then WELC and EDF as parties more in support. I would say the OCD proposal, the NMOGA, that's offering, a lot of changes, not necessarily, in opposition to what OCD has done, but in some areas, just trying to improve or coordinate better. But in any event, so then after the State Land Office, we propose that WELC go next, then EDF and NMOGA last, and then either that same order for rebuttal or reverse order for rebuttal. I don't have an opinion on that. So that would help us if we could establish the order, and we're not wed to that order, but if we could establish that order, that would give our witnesses a little bit better idea of when they would be need to be available to testify.
All right, thank you, Ms. Fox.
Ms. Orth, can I interrupt just for a second?
Yes.
Would it be appropriate to close the record for this meeting before we have this discussion? And then I think the commissioners can probably go if they want. Okay.
Absolutely.
Okay. Well, it is 9:34 and the record for this hearing is now closed, and the line will be kept open so that I don't kick everybody off. I will probably just stop my video and mute. I don't want to kick everybody off of here. So thank you, everybody. And hopefully it sounds like we'll probably follow up on a couple other items that were raised today shortly. All right. Thank you, everybody.
Thank you.
Thank you. So, Mr. Felderwart, on the question